All right, let's jump right in. India has a brand new data privacy law, the DPDPA. But here's the thing, it's already being challenged in the Supreme Court. So what are the big conflicts here, and how are some people proposing we fix them? Let's break it all down.
You know, at the very heart of this whole debate is a classic showdown, your personal right to privacy going head-to-head with the public's right to information. I mean, how can a law possibly protect one without totally sacrificing the other? That's the huge question we're going to explore today.
So let's start with a really big one, a major point of concern for activists and, well, everyday citizens. We're talking about the right to information, or RTI. It's been such a powerful tool, right? It lets people ask the government for information and really promotes transparency. But this new data law might have thrown a serious wrench in the works.
And that leads to this key question: does the DPDPA accidentally create a perfect loophole for secrecy? The worry is that any official could just deny a totally legitimate request for information by saying, "Oh, sorry, privacy concerns." But the proposals we're looking at suggest a pretty clever way around this.
Okay, so what if your RTI request does get denied on privacy grounds? Well, the idea is you're not just stuck. The proposal is to use the DPDPA's own built-in system. First, you'd complain directly to the organization, the data fiduciary. If that goes nowhere, you escalate it to the new Data Protection Board. And believe it or not, you could even take your appeal all the way to the Supreme Court. So it creates a very clear path to fight back.
Now, this proposal gets really specific about what kind of data we're talking about. For example, a public official's contact info, that's pretty much considered already public. But a private citizen's personal info? No way. That absolutely requires their consent, or it has to be anonymized. And this is crucial. If someone tries to de-anonymize that public data to figure out who's who, that would actually be a criminal offense.
And here's a really fascinating twist. If you're the one receiving personal data through an RTI, you might actually have to sign an indemnity. It's basically a legal promise, you declaring that you're using this information for the greater public good. It also means you accept responsibility if you misuse it. This adds a pretty serious layer of accountability for the person making the request.
Okay, but this isn't just about individual citizens filing RTIs. What about the watchdogs of our democracy? I'm talking about investigative journalists and researchers. So much of their important work relies on being able to access personal data.
I mean, just imagine this scenario. It's what has so many journalists worried. If an investigation hits a dead end because the crucial proof is locked away behind a privacy shield, it could really stifle some incredibly important stories. The DPDPA could be a huge roadblock, but the source material we're looking at actually suggests a specific exemption to get around this.
So the idea isn't to give journalists a free pass, but to give them a clear process. They could request an exemption for research purposes, but they'd have to prove to the data holder that the request is genuine. The information might first be released in a pseudonymized format. That just means the names and identifiers are scrambled. And if that's still not enough, well, they can use that same official grievance system to appeal for more.
And to make this official, the proposal floats a pretty radical idea, a register of approved journalists for research. And get this, we're not just talking about traditional media. This could include social media bloggers and influencers, recognizing them as digital journalists who would also have a pathway to access data. Now that raises its own set of questions, doesn't it? Like, who gets to decide who's an approved journalist? It's a really tricky balance to strike.
This whole discussion leads us to another massive concern: government power. Does the DPDPA basically give the state a blank check to access our personal data anytime it wants, just by saying the magic words, national security?
You can really see the two sides of the coin here. The big fear, of course, is unlimited government surveillance. But the author of these proposals pushes back on that idea. They argue that there are actually checks and balances. The exemptions are supposed to be limited, the specific state agency has to be notified, and, they argue, without these powers, criminals could just use privacy laws to hide their activities.
And here's another really important detail in this whole state power equation. To make sure companies cooperate, the government could indemnify them if they're ordered to hand over data. Basically, that means the company could comply with a national security request without having to worry about getting sued by individuals for releasing their data, so long as they acted in good faith.
So when you think about it, all of these debates about RTI, about journalism, about state power, they all boil down to one single massive legal question that the Supreme Court has to figure out. Is the DPDPA, as it's written, a violation of the fundamental right to privacy?
And to understand the challenge, you have to know about the landmark Puttaswamy judgment from back in 2017. This was the case where the Supreme Court declared that privacy is a fundamental right in India. But, and this is the really key part, it also said that this right can have reasonable exemptions.
Now, the author of these proposals makes a very subtle but incredibly important distinction. They argue that this law isn't a blanket Privacy Protection Act. Its goal is actually much narrower. It's designed to protect the right of individuals to control their personal data. That little shift in framing is absolutely key to their whole argument.
And building on that idea, the author argues the law does exactly what it sets out to do. How? By focusing everything around two core concepts. First, requiring your consent to process data, and second, setting clear, purpose-based rules for how that data can be used. And importantly, these same rules apply to everyone, the government and private companies alike.
Which brings us to the author's final, decisive conclusion. They argue that because the law has this very specific purpose and uses a fair process based on consent, it falls squarely within those reasonable exemptions that the Puttaswamy judgment allowed. So in their view, there's actually no legal conflict here at all.
And so we're left with this final, really thought-provoking question. Do all these proposed reforms and interpretations successfully walk that tightrope, creating a necessary balance between our individual rights, public transparency, and national security? Or do they represent a dangerous compromise that ultimately weakens the very freedoms they're supposed to protect? That's the incredibly complex issue that India's Supreme Court is grappling with right now.